Dr. Henry Murigi. Thank you so much for allowing me to have some of your time today to discuss ODR and specifically to discuss your organization, the Nairobi Centre for International Arbitration. I've traveled to Kenya, and it's good to meet a fellow arbitrator, mediator, somebody who's in the field. And so today we're going to just ask you a few questions to take us through what the organization does, and as well as discuss some of what your organization is doing with regards to ODR, online dispute resolution, okay, and how it's impacting the lives of Kenyans. So first off, can you share a little bit about NCIA, the Nairobi Centre for International Arbitration, and discuss for us its founding and its mission?
Okay. Yeah. So first of all, thank you so much, Mark, for creating time to come and meet with me, and also creating an interest on Nairobi Centre for International Arbitration. So we are pleased that you could do this, and thank you so much. Of course, one of the things that we do is to try and make sure that we are available to give as much information to the public and to anyone who would be interested to know what we do. So this is really good for us, and so thank you so much. So NCIA, Nairobi Centre for International Arbitration, is an organization that was set up out of a realization that there was a need in this part of the world to create frameworks that would encourage the use of dispute resolution frameworks, that is mediation, arbitration, conciliation, so that then we are able to inspire businesses and investors that when they come to this part of the world, that is Kenya and East Africa and Africa generally, they would be able to have frameworks that then would resolve their disputes in the manner in which the rest of the world is doing it in terms of dispute resolution. So there was a growing concern that in this part of the world, at least in East Africa, there wasn't any institutions that were doing alternative dispute resolution, and especially international arbitration and mediation. So there was a congress between the Africa-Asia Legal Consultative Group that came up and then decided that it was important that we engage as continents, because what became a reality was that trade was largely moving away from the West, going to the East, and there was an inflow in trade. And then this portend was that then there would be more investors coming in, more business people coming in into this part of the world. So there was a need then for the legal community in these two continents to be able to have engagements and discussions as to how then does it look like. So as a result of that, and as a result of those conversations that were held and conferences that were held, there was a move, and a resolution was made by the ALCO, we call it ALCO, Africa-Asia Legal Consultative Group organization. A resolution was made that centers would be put up in strategic parts of Africa and Asia also. So we have Kenya and Nairobi, there is Kigali, there is Cairo, South Africa, there is Nigeria. So centers were put up to be able to sort of resolve disputes, international disputes that then arise out of commerce and trade that is done by the two continents. And because of this then, NCIA was created in 2013 by an act of parliament. I must give credit always to the founding mind behind NCIA, who is Professor Gideon Muigai, who set up this, at the time was the Attorney General, who set up this center and made sure that the infrastructure, in terms of legal infrastructure, the thinking and the mission and the vision of NCIA was set up. And of course also the founding registrar and CEO of the center, who did a lot of work to set it up to where it is, that is Lawrence Murigi, who did a great commendable job in setting up the center. So the center's mission is to be able to be a premier dispute resolution platform or institution that offers case administration, capacity building, and organizing conferences and international forums for academia, practitioners in the ADR space to be able to converge, come up with the emerging trends on dispute resolution. So we exist to do that. So we have a dual mandate, one that is international and largely to engage at the international space. So if you look at our founding instrument, which is the NCIA Act, it gives us both mandate for domestic arbitration and international arbitration. So we are trying to do a lot more in the international space to create awareness, to also grow the centers in terms of letting the whole world know that we exist as a center. But also domestically, we, of course, have instruction from our constitution to promote ADR. And the center also exists to be able to promote ADR through creating awareness, training leaders, training arbitrators, mediators, and of course also trying to offer an array of services where disputes can be resolved here. We say that NCIA is the premier dispute resolution institution in the country and in the region that offers arbitration services, that is case administration services, at least in this country. So that is, you said in short. I could go on and on, so let me just stop there, but that's the founding mission, to create an institution that would offer mediation, arbitration services, both at the domestic and also at the international level. Yes.
No, thank you for that. And as part of the founding work that you guys do, you do not actually do the mediations and arbitration yourself, right? You actually provide the space for it, you provide the mechanism and the facilitation of it, but you don't actually do it yourself.
Right. So that's actually correct, Mark. So what we do is we do case administration. Let me just unpack that. So, of course, in arbitration, I think you know that we have what we call administered arbitration, which is where an institution takes up the matter and then handles it. We have ad hoc arbitration, where parties go and appoint an arbitrator, mediator, to then resolve the dispute in their own way. So we are an administered arbitration center, where we have a pool of arbitrators, mediators, who then offer dispute who then when cases come to us, we then refer those disputes to them for them to be able to administer the case. So I don't sit in to write awards and so forth. So we have a pool of professionals, both at the domestic and also at the international level, who handle those disputes.
Understand.
Right.
Understand.
Right.
Okay, so can you broadly discuss the evolution of online dispute resolution in Kenya? This is both before the pandemic and since the pandemic. What I like to refer to as the Zoom boom, where everybody had to go online. But what's the story of ODR in this country?
I like that word, Zoom boom.
Yes.
It's actually captures it, because I think before COVID, the pandemic happened, we were largely trying to find our way in the dispute resolution platforms using file documents and using paperwork, making sure that you serve your pleadings to the other party, you file a copy in court, file a copy in the call with the opponent, opposing counsel. So basically, it was all paper, all processes that were known traditionally to be able to be the manner in which disputes are resolved. There was an appreciation, and you could see that in our Evidence Act, where the context was beginning to appreciate that we have something called electronic evidence, and we have something called use of email communication, and how do you then tap that to bring it into evidence, arising from a realization that the world is growing and the world is becoming more aware of technology. But then when COVID happened and there was this shutdown and lockdown, that changed, because for us here in Kenya, in I think February, or is it March of 2020, we were in a totally new space, and because of that, I like your word, Zoom boom happened. Courts began asking, how do we go about this? We can't now send paper. We can now, how do we go about this? So there was a great need and an urgency for us to be able to embrace online dispute resolution, and the uptake has been really phenomenal, if you ask me. I think in this country we have, at least in the judiciary, the good thing is that the judiciary is a good starting point, or it's a good place to begin to see where the thinking is. So I'll use that as an example for explaining Kenya, because I think your question was on Kenya. So the judiciary came up with a very radical initiative which transformed all the processes to go digital and to go online. So all the filing now in this country is done virtually. You go into the e-filing system, you file your pleadings there, the judge looks at it on the other end, gives an order or direction, the other party also files their pleadings, exchange of emails is what is used as method of service. You would hardly need to have the physical documentation prepared. So that is where the judiciary has reached, and they've done a good job. Now the arbitrators and mediators are taking cue and took cue from that time and began to ask, how do we embrace technology and how do we move the conversation forward? So time and time again, we are seeing a lot of arbitrators embracing technology, service of documents, online, registration of cases online. So that is where we are in terms of alternative dispute resolution mechanism. Mediations now are largely done virtually. The other way to look at it is to look at trainings, how are trainings done. We have those ones that require physical, like you would know mediation. Some of it needs to be physical, so that then you can observe the demeanor and observe, so that as a mediator you can guide the parties. So you would need that. But there is also the online one, and there is a great uptake of online dispute resolution in the country in all these other dispute resolution frameworks. So that's what I could say in short answer to your question.
Okay, no, thank you. Would you say that most arbitrations and mediations now are online, or are they still in person, or maybe equal?
So I won't give an empirical answer because I don't have the data to support this. And I say that because we do not have the statistics for the ad hoc arbitrations. But for the ones that we do here at NCIA, we can see time and time again, parties are preferring virtual sessions. In fact, hardly you'd find maybe one or two cases where they require to do a physical mediation. But largely, in a month, you would have maybe one or two hearings. But the rest are just done virtually online. So there's more and more growth in that space. And I'm also aware, because I'm in the arbitration community, that most arbitrators prefer that at least the initial meeting, the preliminary meetings, all those are done virtually. You'd see a few who still want the physical participation. They still that, but more and more evidence is pointing to a different direction.
Understood.
Right.
Okay, so now more specifically, how has NCIA itself implemented technology in facilitating arbitrations and mediations? And you probably covered it already. And I also understand that you yourself don't do the actual mediation or arbitration. So when I was writing the question, I was imagining that you did. But now that I've been more educated by going through all the materials, I understand it. But you can still answer the question.
I mean, it's a fair question. It's a fair question because also it speaks to our processes, and our processes need to be understood correctly, and how we're then embracing technology, or how we're dealing with this emerging issue of technology. So yes, NCIA itself has done an amazing job of trying to digitize all our processes. So we are not there yet. I would say we are at 70-80% of digitizing our processes. All our internal HR, communication, finance, all those matters are all digital. We don't have any physical interface with documents and material there. So all that is online. So, and this means that when parties are filing their cases with us, they expect an engagement online. When there's communication from the center to them, they will receive probably an email and not necessarily a letter. So that is what it means. But for case administration, we have rolled out the process of transitioning to purely physical. And what I mean is, communication and pleadings are exchanged on email. So we want to transition that into a platform where all communication is done on a system, similar to what the judiciary has, the e-filing system. And then our arbitrators can then, log in there and do the work there, and then give justice to the parties. We are doing that because we realized that we need to work together with everybody, all the parties that come to us, all the arbitrators who offer the services, and even ourselves as the Secretariat, to make sure that we are offering purely online dispute resolution. So we're in the process of doing that. I would say we're at 60% complete in terms of rolling that out. And of course also developing a few things. And as you would know, coming up with a system requires testing here, testing there, and so we are doing that with our developer, and we're in good space to say maybe in another less than half a year we should be able to roll it out completely.
Awesome. Right. Well, another half a year or so, I would love to check back in with you guys
Certainly.
to see, you know, how it's coming along, because I know it's a lot of work
Right.
that people don't realize.
Right.
Okay, so now help us imagine it. What does a typical online arbitration or mediation look like in Kenya?
Right. Yeah, so that's a good question because it speaks to the future and speaks also to what is happening. So a typical arbitration that is done online would, first of all, take the traditional format, only that it will be done using Zoom. We call it Zoom Boom.
Yep.
You do it using Zoom or whatever other platform that arbitrators prefer to use. So exchange of communication will be done, like I said, online. No physical documents. Hearings will be done online, and unless, of course, there is a need for the arbitrator to sit in, and because I still think there is a place for one-on-one engagement. So it would be a blend of the two, not purely virtual, purely there will be, or purely physical.
Hybrid.
There will be a hybrid model. So that is what I foresee that dispute resolution would look like. Now, the other frontier that we are beginning to imagine, at least here as NCIA, is those what we call smart contracts, where the contracts where the parties have already determined that a software will be able to be developed to be able to resolve the dispute for us. So we are beginning to imagine that, and of course you would know with the increase in AI and those tools are existing, and we're beginning to imagine that. And one of the things we are trying to do is to engage the thinking hubs like the University of Nairobi to try and come up with models that then could be adopted for dispute resolution. So we're trying to imagine how would that look like. We're trying to tap into the academia to help us come up with that type of policy for purposes of what we call smart contracts, because then how do you determine is this AI justice? Of course, asking the question, what justice is this, all right? What is this the justice the parties want? So having those conversations, I think that will also inform how online dispute resolution will look like into the future.
Okay, but sticking to the question of what does it look like in a typical, scenario, typical day,
right?
What would someone expect when they come visit your center for the first time on your website?
Right.
Let's say as a litigant, as a person who has a problem, what would a typical process look like from beginning to end? And you don't have to go through the details, of course.
Right, yeah.
But is it
No, I don't mind,
weeks,
actually.
months?
Yeah. So we have what we call the NCIA rules on both mediation and arbitration that guide in terms of timelines, and they are available on our website. So if you interact with our rules, they spell out every step and every timeline that is given there, from the point where you're interested in putting in a request for appointment of an arbitrator up to the very end. So it's all spelled out there. But I'll say this. That person who is interested and perhaps is a party who wants to come to NCIA, they just need to go to our website, and then there's an interface there where you begin to key in your details. You'll get there's an email address that is contained there, because sometimes we've seen that parties are not necessarily aware, how do I initiate the process? So that communication, we consider it as the first interaction with a party. So we'll begin to explain to them the processes and begin to then exchange correspondence on email to then now explain, this is what you need to do, these are the requirements, these are the documents we want to see. Of course, we want to see that there's an agreement between the parties to come to NCIA for purposes of dispute resolution. We also want to see that the other party is interested and willing to have NCIA resolve the dispute. Then we move to the next stage, where we then appoint our arbitrator from our panel. That is if the parties do not have a preferred arbitrator. And then now after that, the arbitrator will then go on. And what we do, and which is unique for NCIA, is that our team in case management department sits in to make sure that the arbitrators and the parties are comfortable. We don't sit in there to listen to what the outcome might be or what the parties are saying. We are there to make sure that there is quality, that our services, the ones that we promised to the parties when they came in, that they are getting exactly what they got. The other thing we sit in to do is, which is a big thing in our context, is the costs of arbitration, and they are so high up that parties are beginning to reconsider the idea of arbitration, at least locally. So our center does a little more than just let the arbitrator decide on costs. We sit in to monitor how time is being used, how much time is being spent, so that in the end we then are able to assess and say the arbitrator did a hearing, took about 2 hours, this is the cost, and in our rules we have the capping of what would be charged as cost. So that is a typical.
Yes.
I don't know.
Well, thank you for that. And by the way, I did go to your website and I went to the pricing page and I actually played with the numbers and I changed the number of hours into Kenyan shillings to see how much it would typically cost for a 2-hour arbitration, for example. So it was interesting, and I thank you for having that on there. Actually, I think it will help people have a good idea of what to expect, because cost is always something that people don't want to be surprised by. Okay, so when it comes to your services, how has technology played a role in preparing for and hosting arbitrators and mediators?
Yeah, so that's a good question. So one of the things that we have done as NCIA is engaged in a plan for capacity building. Capacity building that is training arbitrators and preparing them for to offer arbitration services, because we know we have quite a pool of arbitrators, but we want more because the landscape is still so broad. There's so many people who haven't heard about arbitration. So we want to train them in terms of how do they resolve disputes through arbitration, through mediation. So as we do that, we are very deliberate in terms of making sure that the uptake of technology, and as they engage as engaged parties, that they at the forefront are aware of the need to use technology to be able to resolve disputes. This includes how do you constitute your first meeting? How do you call it? How do you then sit in with the parties to make sure that you're addressing all the concerns? How do you communicate with the parties, right? So that, and we're saying as NCIA, we are there in the middle of all that conversation. So we have trained our arbitrators to be prepared to be able to look at some of these matters with the eye of technology. And so our training program, our curriculum is heavy on emphasizing on the use of technology in terms of dispute resolution. The other way we do it is we have these continuous engagements with our arbitrators to help them to know the need to use technology a lot more effectively and use technology appropriately, so that then you don't have AI generated awards. So that we're making sure that there's ethical use of AI, making sure that we are engaging with them on a regular basis. The other thing that we've done to embrace technology is, as NCIA, we have signed what we call the Green Arbitration Pledge. This Green Arbitration Pledge is a task force that was created by a think tank that is looking at how can we make arbitration green? How can we make sure we are responsive to the needs of the environment, the needs of the future generation, and also the needs of the current generation? So Green Arbitration Pledge invites parties to be more aware and to be more aware and also more prepared to reduce on carbon emission and reduce on use of paper and the stuff that goes with that. So we are trying to prepare them. We have given that pledge. So what we do is, when I'm writing an appointment of an arbitrator or mediator, I will make sure that in the letter of appointment, I am very clear that they need to look at the Green Pledge and try and make sure they minimize the use of, or rather whatever services they do, that those services are in line with the Green Pledge, which is to reduce carbon emission, reduce meetings where meetings are not necessary, do it virtually if it has to be, make sure you reduce on the paper, and before you print an email, make sure it's really necessary for you to then print it, and so forth. So we have encouraged our arbitrators, when they are handling disputes, to be aware of the Green Pledge that as NCIA have engaged in. So those three initiatives, I think, are what I would say.
Thank you for speaking on that. All through my travels and discussions, I've never really, I guess, talked to anyone who brought attention to the sustainability part, right? The green portion of it, because that in itself is a driver towards the use of technology.
Right.
And so that's another door, that helps promote ODR.
Can I actually jump onto that?
Please.
Now that you said it in that way, sustainability. We had this conference early this year, in March of this year. And this conference was themed Arbitrating in the Age of Sustainability, having a conversation from practitioners from all over the world, asking the question, how do we make sure that we preserve the environment now, we practice our arbitration and even the services that we offer to parties in a way that is sustainable to the current and the future generation. So we had a conversation around that from practitioners of arbitration, scholars, thinkers, and international arbitrators coming to have this conversation. And one of the things that became clear from the conference is that there is a need for practitioners, and especially in arbitration, to embrace green practices, to embrace sustainable practice, so that some of the things that we need to do, and actually this created a need for even more thought to go into it, to make sure that parties can then embrace technology fully, because if we don't embrace it now, and if we don't take care of the environment now, the future generations, the people who come after us, they will have nothing to look forward to, and it may well be that arbitration will be extinct. So we must then have those conversations. Yeah.
I understand.
Right.
So I understand that you train arbitrators and mediators to become qualified to help people resolve their disputes.
Right.
How has ODR been implemented in your trainings?
Yeah, so this is good. So, and I maybe have alluded to this earlier on in our conversation. What we do is that we offer some of our training programs virtually. So we basically will invite parties to come and attend some of our programs, and this is mediation, arbitration programs, especially at the initial stages where somebody is just curious about what is mediation, what is arbitration. So the introductory ones are more done online, and we try to do that with all these other modules that we then offer here at NCIA. So that is one way. The other way we've done is that in our training curriculum, we have emphasized to our trainers that they must make sure they encourage use of technology, ethical use of technology, so that then parties, or rather the arbitrators who we train, are aware that you could actually leverage on technology to produce a more expeditious and more thorough outcome of the arbitration process. So that's the other way we do it. We include it in our training curriculum, and there's a lot more we do with our trainees in terms of preparing them for use of technology. I just mentioned those two.
I understand.
Right.
So when I was walking through Nairobi, I've seen the e-citizen signs all across town. I did a little bit of research, and I see that your society is very forward-thinking when it comes to technology. How has NCIA integrated its services into the e-citizen platform, if it has?
Yeah. So I wouldn't speak so much about the e-citizen, because it's a platform by one of the government entities that then offers services to all the government citizen-facing service centers. So I'll talk about NCIA. So we have integrated with e-citizen platform because it is like a one-stop shop for all persons who are looking for services from government and from institutions that are offering services that government would offer. So NCIA has integrated with e-citizen, and we are there. In fact, some of our payment processes are done through e-citizen. Some of our services, or rather some of our processes are well integrated with e-citizen, the ones that are citizen facing. But to your point about the Kenyan society and how it has embraced technology, if you travel across, you will see that one of our service providers, mobile service provider, has reached about 50 million 50 million subscribers. Yeah. What that means is that almost everybody in this country, because we're about 55 million as a population, has a smartphone or a phone at least. So what that means is that they have access to communication, they have access to internet. I think in East Africa, Kenya is ranked the leader on matters, use of technology, use of the internet, and all that. But you know what? We have no choice. We have to embrace this, because this is where the world is going. This is the age of communication, an age of information, and we must be at the forefront. So as NCIA, what we're trying to do is to make sure that all the things that we do internally the public is aware about it, so that then we are telling our story to the world as to what we do. And we're telling people all over the world that NCIA is available to offer alternative dispute resolution services that are predictable, that are cost efficient, that are fast. So we are embracing that as NCIA, in addition to using the platforms that have been created by government and other entities to offer.
That makes sense.
Yeah.
So access to justice for all members of society is something that's important to me.
Right.
So how has ODR played a role in increasing this access to Kenyans who might otherwise, they might be too remote from the city center, or they may not have the financial resources to be able to tap into justice. How has ODR helped them?
Yeah, so I think that's a really good question, because one of the things about society is that you must be able to speak to the needs of the people. Our constitution has given us a commandment under Article 48 that we must make sure that access to justice is accessible and affordable. Now, one of the things we must do, and as NCI we are very, very deliberate on, is to make sure that we are engaging the local citizens. As I told you, we have both a domestic and international mandate. So at the domestic, I'll say this briefly, at the domestic level, we are always engaging at the county level. Just this 2-3 months ago, we were in 4 counties. We were in Migori, we were in Nyamira, we were in Bungoma, I think it was, and I think there was another one I'm forgetting. And the idea here is to go and reach to the grassroots, to the people who are not in the urban cities, and to be able to engage with them and sensitize them on this emerging area of dispute resolution practice. But as I wind up on that, the other thing I want to say is that there's a realization in the Kenyan community that justice really is rendered not necessarily through these judicial systems, but it is rendered through engagements and awareness. So what we are doing as NCIA is creating awareness at the local level and encouraging parties who, of course, have access to communication to be able to engage with our services and to prepare them that when you engage with NCIA, when we sensitize you on alternative dispute resolution, when we train you, then you have the equipment and you have the ability to be able to use online dispute resolution mechanism platforms. So we, for example, are training counties, county attorneys who are in far-flung counties of this country. I think there's another call we are going to be going out in the next couple of weeks. We're going to be going out to another part of the country, remote, to be able to reach out to the community there. And what we hope is that and what we have seen is that there's a great uptick for the use of ADR. What we are hoping to see is that there's greater impact in terms of adopting online dispute resolution mechanisms that then can be accessible at every level. Yeah, so that's what I can say, so to answer your question.
Thank you.
Right.
So can you give a snapshot of any current ODR infrastructure that exists in Kenya? And are there plans in the works for further ODR adoption and regulations in Kenya? I know you spoke a little bit earlier to the fact that you guys are building out your own sorts of tools that will be, doing the online dispute resolution work, and hopefully sometime in the next year or so you'll be able to, have that. But what is the current landscape like when it comes to ODR infrastructure, if it exists at all? Yeah.
So the current landscape, what you want to look at is the legal infrastructure that has spoken to the landscape. One of the things that has happened is that Parliament has passed key legislations that have addressed how technology is then adopted, and how it is used in terms of dispute resolution processes, what type of evidence do you present and all that. So that has been addressed by Evidence Act and so many other legislation. Let me not bore you with that. The other way to look at it is to look at what is the government doing, because that tells a lot on where the thinking is going. So we have a policy that has been passed on artificial intelligence that was passed, I think, 2 or 3 months ago, trying to create awareness on this availability of artificial intelligence tools for purposes of whatever service it is, if it's in research, in communication, whatever service it is. So the conversation now in the ADR space is to then how do we make sure that we use practices that are in line with the principles of arbitration to ensure we have confidentiality, which is a critical component, to ensure that we have transparency, and to ensure that we have party consensus, so that parties are agreed. So we're trying to encourage parties and to train parties, especially at the NCIA, to be aware of these artificial intelligence tools and to embrace them and use them ethically. So I can foresee a situation where with this AI framework that is being established, then we can be able to integrate comfortably, addressing all the concerns that would be there by parties, and integrate and then use alternative dispute resolution frameworks that then support dispute resolution. We just did a conference, I think it was in September. We had practitioners from all over the world, a webinar, and I think it's available online, where we discussed at length what are the hits and misses on artificial intelligence for online dispute resolution. So that's something that's an active conversation that we are having.
Well, that's, I think, the conversation of the future, right? What's AR's impact on this and everything else?
Right.
And so that will be for a whole other conversation.
Right.
We could have one day.
Right.
But I'll close with this one last question.
Right.
It's the documentary's question that I've been working on, deals with whether or not ODR can change the world. So how do you imagine ODR can change the lives of Kenyans, of everyday Kenyans, and how can it make things better?
Yeah, I mean, we at NCIA see the potential of ODR, and we see that it creates an opportunity for transformation of dispute resolution, but also access to justice. So on a day-to-day basis, with the availability of technology, with the availability of online dispute resolution services, then every Kenyan would be able to know, to be aware that should a dispute arise between me and my fellow citizen, then I'm aware of a situation or a framework that exists that then would help in dispute resolution. So the answer to the question, to your project question, is that yes, ODR is the current and the future of dispute resolution, and we cannot ignore it and we cannot avoid it. We have to embrace it, make it work for practitioners. Our Kenyan judiciary is doing exactly that, allowing citizens to approach and upload whatever case they have and then be able to resolve it. I know their complaint is on backlog because now with access comes in backlog, and our answer to that, there's alternative dispute resolution mechanisms that exist. We are training our arbitrators to be ready for these types of disputes. So that's the future that I see.
Yes, so thank you so much for this conversation.
Right.
Thank you so much for introducing me to ADR in Kenya,
Right.
ADR in Nairobi, and the work you guys are doing,
Right.
and East Africa generally.
Right.
But also, I'm beginning to understand that it's called the Nairobi Centre for International Arbitration, but it's not just for Nairobi.
Right.
It's not just international, it's domestic as well. And it's not just for arbitration, it's also for mediation.
Right.
But I guess NCIA is a much shorter name. We would not want to keep it going forever.
Right.
So, Dr. Murigi,
Correct.
thank you so much, for...
You got it right.
Yes.
Thank you.
Thank you so much for coming on today on the LMI podcast and on the documentary. And we're going to try to make sure that we get this information out to the public, and we'll share with you the product.
My pleasure.
Thank
Thank
you
you so much. Thank you so much for doing this.